I'm Agris Bitāns, attorney at law with a more than 30 years legal experience. Today, my conversation will be with Kristina Janušauskaite. She is a Director of Legal Affairs at IFPI, and we will talk about intellectual property and artificial intelligence. Thank you, Kristina, for your willingness to join my podcast, and also after your nice and interesting presentation regarding generative AI and copyrights. So could you provide once more again your thoughts about legal and policy perspectives? Do you believe it substantially influence copyright or not? And do you have any feelings about threats, future, about generative AI and copyright?
Thank you very much.
And maybe at the beginning you could provide information about your organization, IFPI, because maybe not all are familiar.
IFPI is a global trade body that represents the interests of record companies, music record companies across the globe. We represent 8,000 members. Some of them you know, such as Universal Music Group, Sony Music Entertainment, Warner Music Group. So we do have indeed a lot of work in the context of the issues related to generative AI and copyright. There's been already a debate ongoing at the EU level, but also at national level. So I'm happy to speak very briefly about some challenges and maybe some opportunities that both are represented by AI. So on the EU-related issues, I will certainly mention the EU AI Act, which was, in our view, the world-class leading regulation in relation to generative AI, because it introduced the first in the world GPI-related obligations in relation to copyright compliance, and also the transparency, the disclosure regarding the data that has been used in the context of the training of Gen AI models. And this is something that is crucial to the industry, and I would say right holders community at large. At the moment, we are, as the industry and the rest of our colleagues in that community, very much focused on the implementation of this regulation. And in particular, we are looking forward to see how the transparency template that is supposed to enable rights holders to exercise and enforce rights in the context of generative AI will be applied. And this is obviously a lot of work that also goes from our side into that debate and the conversation. So in terms or in parallel to this process, I would obviously mention the general copyright issues that are also being discussed at EU level. And we do have some pending initiatives at EU level, such as the European Parliament Jury Committee own initiative report on copyright and generative AI that would also look at the issues just beyond the, let's say, the AI Act related transparency. Then we also have issues in relation to personality rights that go beyond the copyright law as such, which are also crucial, in particular to the artist community. And obviously, we're looking how to make things work, practically speaking. So basically asking ourselves the question, do we have enough tools to help our industry and other rights holders to enforce and exercise their rights meaningfully and effectively? So enforcement measures and so on and so forth. So this is a little bit on the legal side of things. And obviously AI, speaking generally, also poses a lot of societal issues, moral questions, questions of competition, on human factor and the copyright regulation at large, I would say. What is copyright protected content? Does the generative AI created output protectable under the copyright rules? Looking at this from the current perspective, as the law stands today, obviously copyright protects human authorship, original human creation. And I think this is, for now, is the answer. So none of the generative AI output perhaps reaches those requirements. What happens next, it's only the time that will show.
Intellectual property is regulated by several legal acts, starting with international level, different types of treaties or conventions, also regional treaties and also, for instance, in European Union we have directives and regulations, and of course national legislation also regulates the intellectual property. Okay, first of all, we can say the concept of authorship belongs to the human, still is safe, yes?
Under the law, this is the condition. And once, you know, the copyright legislation in many aspects, also looking historically, has been flexible enough to allow, at one hand, the creation, right, the protection of human creation, and in all forms and shapes, and at the same time it has been built in such a way to allow also technological development. So although obviously generative AI brings in a lot of new aspects, I think copyright law as it stands today is still a good framework to navigate within and to benefit from both sides.
And the second question would be related outcome. That means, in your opinion, the generative AI created outcome, it's not protectable by itself.
I think we need to distinguish two things, because AI, we're obviously talking about the challenges, AI also represents an opportunity. So AI, generative AI models are being used in the creative process as well. Here we have to distinguish what is purely AI generated output and what is generative AI assisted output, right? And here again, coming back to what copyright protects, there is a difference. Nowadays, purely AI generated output is not copyrightable because there is no human intervention, creativity, and so on and so forth. While Gen AI assisted output, where I can use, you know, some sort of sequence or some details of technology in my creative work, again, that might bring the result, which would be copyright protected, despite the fact that some generative AI model helped, you know, input was that. So.
Okay, and the next question is related to the question of use copyrighted protected works for AI training. Is it issue or not? Is it solved yet nowadays, or we need to add something in legislation, or we should wait for case law in this case?
It's an enormous issue, as you can imagine, because for some time the general purpose AI models have been trained, as we know it, generally speaking, on the basis of copyrightable content. The question is, how do we know about this, right? So this brings us back to the issue of disclosure. So the transparency requirements that I've mentioned, which we have under the AI Act. So it is crucial that rights holders know what has been used, scraped, you know, in the training, during the training process, when the big data sets were used to create the Gen AI model. So, and this is coming back to a question, obviously, is a challenge. We need to see how the transparency template would help us with that challenge.
But without only transparency, would be a question about remuneration also substantial?
So this brings us back to a discussion on the text and data mining exception, right, and the exclusive rights more generally. I believe that, first of all, we need to start with a point on exclusive rights as a baseline of the copyright rules, right? Before, to put it simply, before you use copyrightable material, as a matter of fact, you need to obtain a permission, an authorization from the copyright owner. Then, obviously, there are cases in the legislation, when we speak about Europe, which provide for exceptions and limitations concerning copyright. That would be the different case in the United States, where this is regulated under the fair use concept. So coming back to those exceptions, the exception in question here would be the text and data mining exception under Article 4. And here comes the question, so how much that exception could be applied to the generative AI as the first question. And if it does, we should not forget that that exception contains certain conditions, such as lawful access and the reservation of rights. So before the exceptions practically apply, those two conditions must be met. So if Gen AI model developer would want to mine certain data and use for the development of a model, that developer would have to, first of all, have lawful access to certain material. That's a question, what it actually means. And second, as a second step, it would have to observe if rights holders reserved certain rights for that, for the text and data mining. And here comes the question again, what that means. In our case, as far as the music industry is concerned, our labels have reserved their rights in connection to text and data mining. So, but that might not necessarily be the case for the other rights holders. So again, there is a big debate what it actually entails, how this opt-out, it's called differently, works, or where to find information about it, and so on. But the industry is doing a lot already to inform about that.
From Kristina's presentation, the main idea is music industry is still not afraid from artificial intelligence. Of course, they are ready, they are preparing, putting necessary regulations or restrictions, for instance, opt-out principles. So they would like to not allow use their products in AI training without their permission or without receiving a reasonable remuneration. So that means that this exception of text and data mining is under question. It's not, is it directly generally applicable or not, but in any case, even if that would be introduced in local legislation, in any case, authors still have rights to opt out, even if such a general exception will be applicable.
Yeah. So there are questions which relate to the fact whether Article 4 actually was drafted and adopted with generative AI in mind. That's sort of a question that we most likely will have, to see how the courts would answer that question. Again, my personal belief is that the law must be technology neutral, right? So in some instances, perhaps that was not encompassed, but again, looking at, how this exception is drafted, what conditions are in. Again, we can think, there are different schools of thought, to put it briefly. But in any case, it must be uncontroversial, as the law stands today, that the exception has conditions. So exception is not applicable just like that, right? You have to meet those conditions that are currently in it, as mentioned, lawful access and the reservation of rights.
And whether AI create new infringement opportunities and whether existing legal remedies are sufficient enough to protect the interests of copyright holders. What's your opinion?
This is an interesting question, again, in terms of who would be liable for which kind of infringement. In the context of AI, there's been a debate also at EU level to start looking at those issues. There's been even thinking to have a sort of a liability directive, a liability act that then was not pursued further by the EU policymakers. As the law stands today, again, we would need to go back to the copyright legislation, national copyright rules to understand. And I think the current rules already provide some, at least, the answers when it comes who is liable, the one who does the reproduction and extraction. Then obviously we need to see whether that goes further. The complexity is also due to the fact that, for example, the AI Act included some provisions in relation to the jurisdictional aspects of the issue, by mentioning that despite the fact where the training took place, the GPI model providers would still have to comply with the rules under the AI Act. So again, there is no one answer today. We most probably would need to see the interpretation by the courts of these rules, but these are all the issues that make, you know, the answer even more complex. So this is more on the infringement side of things. And then on the remedies and measures, here I think we need to start thinking of how to make the current rules also to work more effectively. We do have a set of rules, the EU Enforcement Directive of 2004, we do have injunctions, we do have certain other, you know, measures and remedies provided there, and obviously in the national law. We need now to see if that is fit for purpose when it comes to generative AI. For example, we do not have all the jurisdictions applying catalog-wide injunctions, which might be useful and actually quite crucial in the context of Gen AI-related infringements. So, food for thought, a lot to do.
As regarding artificial intelligence, of course, intellectual property is under challenges, several challenges. As we know, during a technological revolution, this issue or question raised several times. Even we remember that video technology came in force. There was a song about video killed radio stars. So I believe the same issue will be here. But of course, this technology step is much substantial. And of course, we will see how will court will pass judgments regarding already created AI systems, because not all of them have received permission or authorization from authors or other intellectual property right holders, and also would be necessary for them to pay remuneration for used copyright and intellectual property protected works in AI training proceedings. Okay, I hope you are a right person to answer to my question. Whether musical industry is afraid from AI. So as I mentioned during conference, maybe we should change the title of the song, "Video killed the radio star" to the "AI killed the IPR," or you still feel strong and you're not afraid from the future?
This also historically, we discussed that there were moments where everyone thought that the internet would kill copyright, or that the record would kill copyright. So again, it's not to underestimate the impact of generative AI. At the same time, I think in particular as copyright lawyers, we do have this belief in the copyright system as the flexible system going forward. So instead of trying to change the legislation, I think we can try to ensure, and I think copyright law is the law that is built in a very balanced way to ensure that the exclusive rights are protected on one hand, and by, you know, having exceptions, limitations, the interests of the others are protected. Again, many things are very much dependent on how practice works, right? So many things we can learn by just trying to apply and see what this brings us.
Okay, so with a positive view that copyright will still survive, I would like to say thank you very much, Ačiū, for an interesting conversation.
Thank you very much, Agris, also for inviting me. It's been a pleasure.